career, I've centered much of my own research and scholarship on race inequality in the law, interrogating topics such as how legal precedents that appear positive for people of color in this country, like Brown versus Board of Education, may actually help to further white supremacy, and how legal outcomes in cases involving police and quasi-police killings of unarmed Black people result in cultural trauma or group-based trauma for Blacks as a community, with an impact that forever shapes the memories and identity of Black people in the United States. Issues concerning race, law, and inequality are important to me as a personal matter and as a matter of scholarship, just as they are to many legal, sociological, and humanistic scholars around the world today, and to so many of you who have logged on for this lecture. But the year 2020 in particular has placed a magnifying lens on issues of race, law, and inequality. To begin, the disproportionate impact that the COVID-19 crisis has had on the physical, the mental, the emotional, the economic well-being of people of color in this country, particularly Black and Brown people, has shed light on the issues of disparate medical treatment based on race, whether that's due to explicit or implicit biases. The pandemic has revealed the severity of continued disparities in the educational and labor market, with people of color vastly overrepresented in essential workers on the front lines in healthcare, in food service, and delivery service, and people of color vastly overrepresented among those who've been laid off and furloughed from their jobs, and who have lost their housing and who stand on the edge of losing their housing. The year 2020 brought the horrifying murder of George Floyd by former officer Derek Chauvin in Minneapolis. And that was preceded by tragic killings of Breonna Taylor, Ahmaud Arbery, and Tony McDade. And that was followed by equally tragic killings of Rayshard Brooks and David McAtee, among many others. And in the year 2020, as my colleague, Professor Karen Peter-Lohr tells us, we are experiencing an uprising unlike anything we've seen since the civil rights movement of the 1950s and 60s, with a demographic makeup unlike anything we've seen before. So although it's always been important to consider the relationship between race and the law, a relationship that has been inherent to our society since the founding of this country, it is critical that we maximize this moment to educate ourselves, to challenge ourselves and our communities and our institutions to change and to be better. It's important that we as a nation acknowledge our entire history, that we teach that history in our schools, and that we take action in examining and changing a legal system that has routinely worked to facilitate and excuse racism, whether that was intentional or not, or whether it is intentional or not. Our new speaker series on race, law, and inequality is important for all of these reasons and more. So for the first lecture in this new series, we welcome the amazing Deborah Archer from New York University School of Law as our keynote speaker, who will discuss particular ways in which crime-free housing ordinances perpetuate inequality for people of color. Today's lecture is made possible in part by our fantastic Boston Young Alumni Council, Boston University Law School of Law Young Alumni Council. It's a group of BU law graduates from the past years who have chosen to establish their careers here in Greater Boston and who give generously of their time and their talent to support our current students and other alumni, as well as other important initiatives of the school like this lecture series. And I'd like to introduce you to Shreya Kumar, who is a graduate of our class of 2017 with an LLM in American Law. Shreya is a member of the Executive Committee of the Boston Young Alumni Council and co-chair of the Council's Professional Development Committee. She's a senior associate at Mass General Brigham, formerly Partners Healthcare. There she works with the corporation's executives and institutional officials to facilitate their outside work with industry in accordance with corporate policy and regulatory frameworks. And I invite Shreya to offer some brief remarks on behalf of the Boston Young Alumni Council.
Thank you, Dean. Good afternoon, everyone. My name is Shreya Kumar, and I'm the co-chair of the Professional Development Committee of the BU Law Young Alumni Council Boston chapter. The YSC is an alumni organization whose purpose is to foster community between the law school alumni and current students through a variety of social and professional events, as well as through personal connections. We are here to support young alumni wherever that support is needed and create meaningful relationships. The YSC is hosting today's important event because of our commitment to the values of racial equity and justice, and in a sincere effort to further the momentum of this significant dialogue. While not all acts of racial injustice and violence make headlines or ignite protests at a point in time, we are acutely aware that race relations and the issues of racial discrimination, indignities, dehumanization, and violence affect people of color every single day. The YSC is committed to introspection and examining how the law itself, as a part of the institutional structures, perpetuates racism and inequities, and what action, most importantly, we as BU Law graduates and faculty can take through our knowledge and practice of the law to pursue equity, justice, and fundamental change. It is to that end that the YSC is proud to host the first of the Race and the Law Speaker Series presented by Professor Deborah Archer of NYU School of Law and moderated by Professor Jade Brown of Boston University School of Law.
Thank you. Thank you so much, Shreya. I'm also delighted to introduce Jade Brown, a graduate from our class of 2016. She's a new member of our clinical faculty just this fall. Professor Brown will be moderating our today's program, as Shreya just noted, and she teaches in our Civil Litigation and Justice program, which is actually celebrating its 50th anniversary this year. Jade teaches the art of lawyering to the clinic students who practice employment, housing, and family law. And previously she served as a staff attorney at Greater Boston Legal Services, where she practiced housing and consumer law, and she represented clients in a variety of cases involving eviction, foreclosure, debt collection, credit reporting, and fraud cases. Jade also helped to develop a highly regarded Lawyer for the Day debt clinic to represent consumers sued by debt collectors in small claims court. And over the past several months, she's been an active participant in the conversation about the need for greater legal resources for people most deeply affected by the global pandemic, including service as a guest panelist at Representative Ayanna Pressley's recent virtual town hall on COVID-19. So it's my sincere pleasure to introduce one of my newest colleagues, Jade Brown.
Good afternoon, and thank you, Dean Anawachi-Willig, for your opening remarks. And thank you to everyone in the audience for joining us today. Just a few things before we get started. When Professor Deborah Archer is finished with her talk, we will open up the program to questions that you can type directly into the Q&A box. Then immediately following today's program, there will be an opportunity to further discuss Professor Archer's topic in an optional breakout session. The link to access the breakout rooms will be added in the chat box, so keep an eye out for those. These sessions will be facilitated by several of our BU Law faculty members. And you can choose which session you would like to join and head to that breakout room immediately following the Q&A. Now let's get into the introduction for our program. As the Dean stated, I am Jade Brown, and I'm very excited to moderate today's session and to introduce our guest speaker, Professor Deborah Archer of NYU Law School. Professor Archer is an associate professor of clinical law and co-faculty director of the Center on Race, Inequality, and Law at NYU Law School. She's also the director of the Civil Rights Clinic, where she and her students represent clients in a range of civil matters, including employment discrimination, educational equity, voting rights, and criminal justice reform. Professor Archer is nationally recognized as an expert in civil rights and racial justice, and she teaches and writes in the areas of racial injustice, civil rights, and clinical pedagogy. She previously worked as an attorney with the American Civil Liberties Union and the NAACP Legal Defense and Educational Fund, where she litigated in the areas of voting rights, employment discrimination, and school desegregation. Prior to teaching at NYU, Professor Archer was also a member of the faculty at New York Law School for 15 years. Professor Archer is currently a member of the Board of Directors and General Counsel to the Board of the American Civil Liberties Union. She was recently recognized by the New York Law Journal as one of New York's top women in the law. And now I am very pleased to hand the program over to Professor Deborah Archer.
Good afternoon, everyone. Thank you for joining, and thank you, Jade, for the lovely introduction, and thank you to the Dean for inviting me to talk to you about some of my work. My work focuses on how racism persists in its power. I try to identify and challenge the architecture of racial inequality, exploring the laws, policies, cultural norms, and structures through which racism continues to really constrain the life outcomes of some and expand the life outcomes of others. And recently, my research has had a more specific focus on understanding the modern drivers of racial segregation and concentrated poverty. America, as I'm sure everyone knows, remains profoundly segregated along racial lines. We live separately, we learn separately, we socialize separately. And this system that this country has so effectively built to protect and maintain segregated communities have a tremendous negative impact on those who are left out. And this is not because Black people and other people of color would get some magical benefit from living closer to white people or from sitting in classrooms with white people. It's because you cannot separate the places people have access to from the opportunities people have access to. One's home, not only the physical residence, but also the community in which it's located, impacts our lives in numerous and interdependent ways. There is nothing that place does not touch. Our access to education and jobs, our physical safety and our health, our access to healthy food, our social networks, even the quality of the air we breathe are all deeply impacted by where we live. And in so many ways, the history of Black people in America is a history not only of control, but of exclusion, and legal and social limitations on how and where Black people live are really central to that history. These exclusions have proven to be remarkably durable, outliving both chattel slavery and Jim Crow. And the United States really has a deep-rooted history of exiling marginalized people from communities of privilege. Indeed, America has embraced the tradition of exile for centuries. We can start with Native Americans who have long endured attempts at exile, banishment, and extermination. There were government-supported campaigns to exile freed slaves to parts of Africa, first to remove a threat to the institution of slavery, and then later as a proposed solution to racial violence following emancipation. And during World War II, Japanese Americans were forced into internment camps to isolate the threat that they allegedly posed to the country. The embrace of exile was evident in Jim Crow policies around the country, where white people created whites-only spaces like schools, neighborhoods, parks, restaurants, by excluding Black people through violence, through laws, through customs. And more recently, we have forcibly removed or criminalized homeless people and poor people to force them out of urban centers or gentrifying communities. We've banned, segregated, and institutionalized people with disabilities, and we've threatened deportation of immigrants, in some cases who have virtually spent their entire lives living in this country. America's embrace of exile to protect white spaces includes countless acts of racial violence throughout the 19th and 20th centuries. White people, driven by white supremacy and hatred for Black people, use violence, intimidation, and the law to rid their communities of Black people, to separate Black people from opportunity, and to keep Black people in their place, physically, socially, and economically. Today, this country continues to use exile and exclusion as a means to define the boundaries of citizenship and belonging. And given our long, long history of using the narrative myth of Black criminality as a justification for segregation and subjugation, it should be no surprise that central among the modern tools of exclusion are laws allegedly motivated by the desire to keep certain communities safe. One of the newest tools in this arsenal are what I refer to as policing-based housing policies. These housing policies take various forms, but all encourage or require property owners to exclude people with criminal legal system contacts. The adoption of policing-based housing policies has really become entangled with societal assumptions about the criminality of Black people and the criminal legal system's steady march towards mass criminalization. Despite a growing consensus about the harms caused by mass incarceration and many high-profile efforts to reverse America's race-driven over-reliance on imprisonment, mass criminalization has nonetheless seeped into virtually every aspect of our lives and society. Against this backdrop, the adoption of policing-based housing policies act as a system of essentially racialized agreements between community members to exclude people of color. I want to focus some time in on one category of policing-based housing policies, crime-free housing ordinances. And I'm sure that most of you, unfortunately, haven't heard about crime-free housing ordinances. Crime-free housing ordinances are local laws or policies that either encourage or require private landlords to evict tenants who have had varying levels of contact with the criminal legal system, or to decline to rent to those tenants in the first place. These local ordinances have the purported goal of stemming crime in rental housing, but they are far more effective at excluding racial minorities and promoting racial segregation than they are at stemming crime. In their most problematic form, crime-free housing ordinances make even alleged criminal activity a violation of the rental agreement. They allow police officers to decide whether a potential tenant's criminal history disqualifies him from rental housing in the community, or whether a tenant must be evicted because of alleged criminal activity without any meaningful due process. They also allow revocation of a private landlord's authorization to rent her property for failing to act on those police determinations. Significantly, a resident does not have to be convicted in order to be evicted. A common crime-free lease addendum that we see around the country explicitly states that proof of violation shall not require a criminal conviction. This creates the possibility that a mere arrest, or even a stop that results in neither arrest nor conviction, might be sufficient to evict someone from their home. I'm sure you won't be surprised to hear that crime-free ordinances have their roots in the law enforcement community and are historically police-sponsored programs. The first ordinances were created by the International Crime-Free Association, an organization that was founded in 1992 by a member of the Mesa Police Department in Mesa, Arizona. The stated goal of the ICFA is to use law enforcement-based crime prevention strategies to keep illegal activity and the tenants that they believe to bring it off of rental property. The ICFA has really successfully spread the adoption of crime-free housing ordinances across the country. Today, according to one study, over 2,000 municipalities across 44 states have adopted crime-free housing programs. In California, for example, almost 1/3 of local governments have a crime-free ordinance or program. I want to share with you two examples of programs. One mandatory and one voluntary, but both incredibly problematic. The example of a mandatory program is Faribault, Minnesota. First, the ordinance requires a requirement that all owners of rental housing obtain a license from the city to operate a rental dwelling. And the ordinance lays out a series of requirements for obtaining and retaining that license. Excuse me. One of the requirements is compliance with the ordinance's crime-free housing provisions. The ordinance also provides a number of reasons that a landlord's license can be revoked, and it includes failing to actively pursue the eviction of a tenant who has been accused of violating the crime-free lease addendum. Faribault's ordinance also provides the text of a crime-free lease provision that is mandatory for every lease, and it prohibits a resident or guest from engaging in illegal activity on or near the premises. Notably, the ordinance does not define what constitutes illegal activity, making any alleged violation of the law grounds for eviction after a single violation. Finally, the ordinance gives the Faribault Police the power to order eviction of a tenant pursuant to the lease addendum without an arrest or a conviction. If the police department determines that a tenant or occupant is in violation of the provision, the landlord must terminate the tenancy of everyone in the unit and may not enter into a lease with anyone who lived in that apartment for a year after that. Orlando, Florida is an example of a voluntary program. An Orlando police officer described the program as designed to, quote, squeeze out all of the people who just don't want to do right, so good people can have a nice, quiet place to live. The Orlando program has several components. The centerpiece of the program allows a property to advertise that it is crime-free if the property management agrees to include a specific crime-free lease addendum in all of its leases. The language in the Orlando lease provides that once a property owner or manager is notified that a tenant has been arrested, they can fill out an eviction form and give the accused resident just 7 days to move out. Again, a resident does not have to be convicted in order to be evicted. Properties that participate in the crime-free program also receive a weekly tenant eviction list, which identifies all renters who have been evicted pursuant to the crime-free program. And the purpose of this list, according to the City of Orlando, is to ensure that someone who's evicted under the program from one house will not be able to move to new housing in the community. They want to ensure that people have been locked out of the community entirely. Although Orlando's program is nominally voluntary, in the 5 years between 2009 and 2014, approximately 1,400 renters were evicted under the program. And the overwhelming majority of those evicted were Black and Latinx. One of those people was Leroy E. Banks. He was 21 when police suspected that he broke into a car. Police questioned him and he denied any involvement. But in connection with his questioning, the police checked Mr. E. Banks' criminal history, which showed that he had 2 prior arrests, but no convictions. The officers turned that information over to the rental complex where he lived, and the building management immediately started eviction proceedings, and he was evicted from his home within a week. It's no surprise that crime-free housing ordinances disproportionately exclude and target people of color. Involvement with the criminal legal system effectively functions as a racialized criterion for who can live in that community. This is because there are extreme racial disparities in who has contact with the criminal legal system. The impact is heightened because of the breadth of crime-free ordinances. The exclusions are not only based on convictions, but by design and implementation on any contact with the criminal legal system, from convictions to arrests to even stops and mere suspicion. The discretion that these laws give to police officers and landlords is ripe for abuse. It's easy to see how bias by law enforcement and the disproportionate enforcement of criminal laws leads to a regime where people are excluded from housing and community for reasons having nothing to do with safety and everything to do with racism. In Hesperia, California, a city with a particularly onerous mandatory ordinance, the United States Department of Justice determined just last year that Black residents were almost 4 times more likely than white residents to be evicted under the city's crime-free housing policy. And Latinx renters were 3 times more likely than white tenants to face eviction. The DOJ also determined that nearly all evictions under the policy occurred in non-white neighborhoods within the city of Hesperia. And it's not just the potential for abuse that is problematic. There is evidence surrounding the adoption of these ordinances that racial segregation may be more than an unfortunate byproduct. Crime-free housing ordinances are often adopted following burgeoning racial diversity, not burgeoning crime. For example, of the 20 California cities with the largest increase in Black population since 1990, 18 of that 20 have a crime-free ordinance or policy. And of the 20 California cities with the largest increase in Latinx population since 1990, 16 of those cities have a crime-free housing ordinance or policy. Again, Faribault, Minnesota is an instructive example. The Faribault crime-free ordinance, which I discussed a little earlier, was passed in 2014 with a purported goal of getting rid of, quote, problem tenants living in downtown Faribault. There's a reason to believe that that language, problem tenants, operated as a dog whistle, because nearly all of the racial and ethnic minority households in downtown Faribault live in rental housing. Also, the Black population of Faribault, composed almost entirely of Somali immigrants and refugees, nearly tripled between 2000 and 2010. The 2010 census showed an increase of 214% in Faribault's Black population since 2000, and 263% increase in the Black population living in the downtown area of Faribault during the same period. And although residents of Faribault began complaining about increases in crime during this period, the overall crime rates in Faribault did not, in fact, increase. And it was immediately after the city council learned of this increase in the Black population that discussions started about adopting a crime-free housing ordinance. These ordinances ultimately ensnare people who have not engaged in activities that meet any reasonable notions of crime. The entanglement of policing-based housing policies and mass criminalization is really pushing already marginalized people further to the edges of society. And the more we criminalize relatively innocuous behavior, the worse the problem gets. In the end, these policies exclude people who pose little or no threat to the community. Families banned because their children engaged in behavior that would be of little consequence in other communities. People fighting substance abuse disorders and searching for stable housing to support their recovery. People targeted by the over-policing of Black people and Black communities, and the victims of the weaponization of the police. I want you to consider the case of Thelma Jones, a Black woman who lives in Faribault. After living in Faribault for almost a decade in her then apartment for 5 years, Ms. Jones was informed by her landlord that she and her children had 2 weeks to move out. The landlord told Ms. Jones that the police advised the landlord to evict Ms. Jones because the police had responded to complaints at her home more than 82 times and characterized Ms. Jones's home as a location of ongoing criminal activity. In fact, Ms. Jones and her children didn't have any criminal convictions. However, the police had come to Ms. Jones's home repeatedly because of harassing calls to the police by her white neighbors. On one occasion, police responded to calls because Ms. Jones was hosting a family barbecue. On another occasion, police were called when Ms. Jones hosted a child's birthday party. Police even responded to calls when her children were outside playing on their trampoline. Ms. Jones and her family were evicted not because they were engaged in criminal activity, but because she was a Black woman who was unwelcome by her predominantly white neighbors. Although many policymakers point to crime as a primary motivation behind the proliferation of policing-based housing policies and the desire to exclude, the problem isn't actually crime, but the myth of criminality. Racial bias permeates mass criminalization. Indeed, the narrative linking race and crime has endured for centuries. And today, Americans' fear of crime has morphed with America's fear of Black people. In conversations ranging from criminal justice reform to education to housing, this racialized narrative fuels a general state of anxiety and fear and brands Black people as dangerous and inhuman. Mass criminalization feeds the myth of criminality and validates unwarranted fear. In turn, crime-free housing ordinances weaponize that fear. Today, Americans are having a long overdue conversation about the need to reimagine policing and public safety. But this conversation really has to be about more than a re-examination of traditional policing. It must also examine the expanding role and power of the police. Crime-free housing ordinances are a move in the wrong direction because they provide an already racist criminal legal system with a broader province of impact and influence. Race plays an undeniable role in policing in the United States. And by utilizing the principles of policing in both design and implementation, crime-free ordinances import racially discriminatory policing practices into the private housing market and weave housing policy and the criminal legal system together both ideologically and functionally. Ideologically, the normative values of the criminal legal system are infiltrating housing determinations. Housing policy is adopting the policing-based values of exclusion and punishment and treating applicants and tenants as suspects, blurring the line between housing determinations and policing. Functionally, crime-free housing policies give police officers outsized power to determine who can and cannot live in certain communities. These policies essentially allow police officers to pick and choose who may live in their community simply by making the practically unreviewable assertion that an applicant or tenant engaged in illegal activity. Ultimately, the denial of housing is used to punish criminalized people, both those with meaningful criminal legal system contacts and increasingly those without. The consequences for those exiled are devastating. And given the close connection between law enforcement, the criminal legal system, and race, for many people of color, exile is almost fate. Thank you for listening, and I look forward to your questions.
Thank you so much, Professor Archer. Looks like we have a few questions, or we have a question from Professor Stipe. The question is, I've heard that since 2010, a number of states and localities have adopted ban the box or fair chance policies, many of which prohibit private employers from screening out job applicants who have convictions or arrest records before considering the applicant's qualifications. I wonder whether you consider this development promising for a reversal of crime-free housing ordinances and policies, or whether the employment context is different from the housing context in significant ways.
Yeah, no, I think the employment context is incredibly helpful in how we think about the way that we engage with people who have had contacts with the criminal legal system. And in New York, in the employment context, you can't ask those questions until you've made initial assessment of an individual's qualifications. We saw some moves in that direction in the housing context under the Obama administration. There were guidances that were released that warned about the disparate impact of using criminal legal context to make housing decisions, and encouraged people to find other ways, and also addressed trying to more holistically assess any criminal history, looking at the time since that conviction, the nature of the conviction, and what an individual has done with their lives since that time. So I do think that that's promising. Unfortunately, under the current administration, they've backed away from trying to enforce that, to expand that value and consideration. So it will help in a small segment of crime-free housing ordinances. But as I mentioned, one of the big problems with crime-free housing ordinances is that it doesn't actually require that anyone have a criminal history record. It can be that you have had any kind of contact with the police, and the police have determined that you are engaged in illegal activity. In the context of Faribault, one of the police officers who runs their program said in an interview that he encourages in his trainings that he has for landlords and property managers, that they should go beyond criminal background checks. Because in his words, just because there isn't a record doesn't mean that there isn't a wealth of information. And instead, people should come down to the police department and talk to officers about what they know about individuals in the community. So certainly kind of ban the box effort within the housing context would help. But in the context of crime-free housing ordinances, it really still wouldn't be enough.
Thank you, Deborah. And I think one of the things that's hard for people to wrap their heads around, I know it was hard for me when I started out in legal services and started doing housing eviction cases, is the idea that someone could be evicted purely based on an allegation of criminality. There's no due process requirement here. If you look at the model leases that a lot of landlords in the Boston area use, they're based on the HUD model lease form, which has a provision that you can evict a tenant for criminal activity. It doesn't define criminal activity, and it doesn't require that the tenant actually be convicted. So You know, sometimes you have allegations of a fight, for example, between two tenants, and the landlord could choose to evict one of the tenants or both of them simply based on the allegation. There's no requirement that that person actually be convicted of assault or anything like that. And I think that leads in to the next question that we have, which is from Mr. Mark Schwartz, and it asks, do any communities in the Boston area have crime-free housing ordinances?
So I don't know off the top of my head, but I certainly could research that. I would be shocked if there wasn't. There are communities in Massachusetts that have them, so I would be surprised if Boston didn't have them. And Boston may not, even if they didn't have crime-free housing ordinances, I know that they are using other policing-based housing policies, particularly in public housing, as you mentioned as well. So I don't know if they have them in Boston, but they do have them in Massachusetts, and they are growing around the country. If you are engaged or want to be engaged in doing research to determine if your community has a crime-free housing ordinance, you'll find that it's incredibly difficult to identify all of them. Certainly if it's an ordinance that the city has adopted, it's a little easier to determine, but some of these programs you won't know about unless you search the police department's website or search the city's website to find reference to these voluntary programs that in effect still have the kind of detrimental impact that the mandatory programs have. And not everyone uses the term crime-free housing ordinances. So you will actually have to expand your search and look to the substance of these programs as opposed to solely relying on the name crime-free housing ordinance.
Thank you, Deborah. Our next question is from Professor David Rossman, and the question is, have challenges been made on racial equity grounds to the one strike policy that HUD has in its regulations, which require all housing authorities and Section 8 landlords to put in their leases a similar provision also allowing evictions for criminality? So this touches on my earlier point about, you know, my observations in that area.
And there was a challenge, and Jade, you can correct me if I'm wrong, I believe the name of the case is Rucker, R-U-C-K-E-R, that went up to the Supreme Court to try to challenge this kind of policing-based exclusions in the public housing context. And the Supreme Court said that there was no problem with them at all. And I saw that after that decision, there really was an explosion in the number of crime-free housing ordinances in private housing because they saw the Supreme Court as giving a green light. Luckily, I think there's more attention being paid to crime-free housing ordinances. There are some legal challenges around the country. I know of a few. As I mentioned, the Department of Justice is suing the Hesperia, California, over their crime-free housing program. In that context, they are alleging intentional discrimination in the application of the crime-free housing ordinance. In Faribault, Minnesota, the ACLU Racial Justice Program is suing to challenge their program, and they're alleging intentional discrimination in the adoption of the ordinance, in the application of the ordinance, but they're also pursuing two disparate impact claims under the Fair Housing Act. One, a traditional disparate impact claim, and the other, a segregative effects claim. And the segregative effects provision is something that people don't really use often and haven't used under the Fair Housing Act, but it certainly has the potential here in this context because that clause of the Fair Housing Act makes it illegal to adopt policies, programs, or practices that create, increase, reinforce, or perpetuate segregated housing patterns. And we can certainly see how crime-free housing ordinances does all of those things. And so those are two legal challenges I'm aware of. And I'm also aware of communities around the country that are engaged in more legislative advocacy, education, public education campaigns to try to get cities to voluntarily stop enforcing their crime-free housing programs.
Thank you, Deborah. And I will say based on my own knowledge, I mean, the Seminole case in Massachusetts, it's BHA versus Garcia. And in that case, the court upheld the Boston Housing Authority's ability to evict a tenant based on, alleged criminal activities by her children. So that's still the leading case in Massachusetts. I'll go to the next question, which is from Mr. Daniel Balls. The question is, are the 7-day eviction notices subject to judicial review?
So under every crime-free housing ordinance that I looked at or program, the tenant can go to housing court to challenge their eviction. But the reality is that most tenants don't go to housing court to challenge their eviction. And there's the additional challenge here that for those tenants that do go to housing court to challenge their eviction, they're not represented by counsel. And you have the additional burden of trying to challenge the allegation that you are engaged in criminal legal activity without having access to the police records or other information that form the basis, or knowing that you should have access to that information. So in effect, there is the ability to review, but most people don't challenge their evictions. And there's also the challenge on the other end, that for people who are denied housing because of these crime-free housing ordinances and are excluded from the community that way, they may not know the basis for their exclusion. I recently became aware of a story in California where a single father who has a criminal history was having trouble finding housing. In community after community after community, he and his daughter were being denied housing. And he eventually realized that it was because of the crime-free housing ordinances that are just so popular in California. And he is then now going to be able to challenge that, but he's, I think, unusual in that most people who are seeking housing don't make the connection between their denial and the crime-free housing program.
Thank you, Deborah. Our next question comes from Ms. Allison Jones. And the question is, what do you think is the most effective way to challenge these type of ordinances and their effects?
Yeah, I'm a fan of integrated advocacy. That's what I teach my clinic students to engage in. And that's, litigation, public education, legislative advocacy, community organizing, all working together to move the needle closer to justice. And so in the context of crime-free housing ordinances, I think we have to use all of those tools. So first is litigation, and I mentioned the Fair Housing Act. And I did write an article that explores some of the potential claims under the Fair Housing Act. And in fact, I wrote that article and then talked about Hesperia in it, and was contacted after that by the Department of Justice when they were considering doing their Hesperia litigation. I also think that you can use intentional discrimination claims, but we shouldn't just rely on litigation here. I think that there are, public education would be important. I think a lot of communities, if they realize the impact that these ordinances have, that they would push back, or they would stop using and stop enforcing these policies. That happened in Georgia. In predominantly Black communities, an advocacy organization reached out to them and explained the impact of these ordinances, and they ended their programs. It's also happened in predominantly white communities. I know of some in Florida and again in Georgia. So public education helps. Engagement with our legislators in these communities will help, but if all else fails, then I think litigation is an option.
Thank you, Deborah. Yeah, I think certainly, I believe it was Professor Rossman that asked the question about the, in the employment context, and I think certainly all of those strategies that you mentioned were employed in that context to sort of change the dynamic and sort of change the laws there. I like the idea of integrated advocacy, and I think as lawyers, we often approach everything from a litigation stance. So it's interesting to think about ways that lawyers, community activists can work together to potentially change these criminal ordinances.
And in fact, I know this is just this conversation so far is focused on these ordinances, but the integrated advocacy strategy, I think, is important for us to address all racial injustice and systemic discrimination. It's difficult, particularly because of what the courts have done and how they've interpreted civil rights law. It's difficult to use our current civil rights statutes to attack some of the deeply entrenched, complicated, systemic discrimination that intertwines public and private discrimination. And so we are really in a position where we have no choice but to figure out how, as lawyers, to engage with these issues outside of the context of litigation.
Yes. So we have a question from Miss Amy Brown, and the question is, are landlords doing criminal background checks on all of their current tenants once a policy has passed? So I think this question relates to in areas where there's a new policy that comes into place, do landlords then start doing the background checks on their existing tenants?
Yeah, so I didn't spend a lot of time on the background check piece of it, but it is an important part of crime-free housing ordinances. In Faribault, landlords are required to do a criminal background check on any applicant to their housing or a current tenant, and to go back, I believe it was 5 years, but then also to hold on to that background check for at least 1 year, and then to show proof that you've done it if the police ask you for proof, and not conducting that background check is grounds for you to lose your license to rent. And so in certain communities, they are requiring landlords to not only at the adoption of the program to do criminal background checks for new applicants for housing, but to do those background checks on their current tenants as well.
Yeah, I think certainly we see in the context of the tenant screenings for new applicants that the background checks would be happening, but I think it's interesting to think about the idea that landlords might start screening even existing tenants, and whether if they were to find a criminal record at that point, they could move to evict based on a criminal record that was prior to the existence of the tenancy. I would think at least, we would hope that if that were happening, that tenants might have some legal help, because that certainly seems perverse, even more so than the existing standards. And we have a question from Miss Jasmine, or Professor Jasmine Gonzalez Rose. It says, you talked about the expanded role and power of the police. One expansion over the past decade has been increased immigration enforcement by local police. Does this intersect with crime-free housing ordinances?
So absolutely, we have seen in some communities that Latinx populations in particular are experiencing that intersection of immigration enforcement and the crime-free housing policies. It hasn't been an area of work that I focused on in my research, but I know that the ACLU Racial Justice program is aware of that intersection. They've gotten lots of concerns from people, particularly in Faribault, once they heard that the ACLU was challenging one aspect of this program, wanted to share their concerns about other aspects. And so I know that there are folks on the ground who are looking into it, and I'm happy to share that information with you as I learn more about it.
Thank you, Deborah. Our next question is from Mr. Steve Randalls, and it says, what have been the ways to challenge crime-free housing ordinances via legal actions?
So I mentioned that folks can challenge them by challenging their eviction. Landlords also are given some due process protection, more due process protections than the tenants, to challenge revocation of their license under the program. But challenging wholesale, as I mentioned, there have been exploration of and use of constitutional challenges and challenges under the Fair Housing Act. I'm sure there are other challenges. The challenges under the Fair Housing Act and the Constitution are really focused on the rights of tenants and challenging discrimination experienced by tenants and applicants for housing. but I'm sure there are property law scholars who can think of very creative ways to challenge these ordinances on behalf of the landlords. Maybe as a taking, but right, so taking away their ability to use their property as they see fit. But those are the ones that I'm aware of.
Thank you, Deborah. And switching a little bit to the idea of Black criminality, we have a question from Mr. Charlie DeWitt. And the question is, what is the first step to eliminating this assumption of Black people as dangerous and thus, you know, moving towards elimination of discrimination in housing policy?
I want to be optimistic in my response, which is why I'm pausing. But I'm not optimistic about the ability to eliminate wholesale this idea of Black criminality and the role that it plays in virtually every aspect of our lives. So much of the history of the United States is about control, domination, subjugation of Black people, and using police to accomplish that goal, and intertwining the story of criminality with the need and desire to control Black people. So it's going to take a lot to unravel this connection that we see. And I don't think that just talking about the existence of that narrative is there. It has to be an attack on many sides. It's about the media that helps perpetuate those stories. It's about challenging narratives that have the belief of excessive Black criminality buried into those narratives and pulling them out, unearthing them, calling them out, and challenging them. It's about challenging a whole host of systems that are built on the idea of Black criminality and the need to control Black people. And that includes public assistance and our family law systems and family court. All of these systems have built into them this narrative and understanding of Black criminality. And we're really not going to make progress until we acknowledge the history and then challenge the ways in every single system where we see it manifesting.
Thank you, Professor Archer. We have a question from Professor Gary Lawson, and the question is, the paper talks about the FHA as a possible basis for challenge to these ordinances. To what extent does that depend on the contingent content of regulations?
So, of course, I think each of these regulations you'll have to craft a challenge based on the specific language. But if you look at the version that I see that is most prevalent, that requires kind of blanket criminal background checks, that doesn't define illegal activity, that allows for evictions based on arrests and suspicion, then I think that those are going to be susceptible to the Fair Housing Act. It's because even if you accept the idea and notion that these ordinances will advance some measure of public safety, the amount of benefit to public safety that you get really pales in comparison to the damage and impact it's going to have on perpetuating racial segregation. And also those components that are most heavily the ones that are going to perpetuate racial segregation and exclusion aren't necessary, aren't linked to achieving the goal of safety. So even if you could arguably say that it's important to exclude people with criminal convictions from housing in order to protect the other tenants and protect the community, it doesn't mean that you need to exclude everyone with criminal convictions. It doesn't mean that someone who has a criminal conviction 40 years ago and since then has been an amazing member of their community and has done wonderful things should be excluded. And it also doesn't mean if you can prove that some convictions will lead to safer communities, it doesn't mean that and justify excluding people based on other criminal legal system contacts like arrests or suspicion, which really mean nothing, which prove nothing, and which show nothing. So I think under the Fair Housing Act, you wouldn't be able to justify the exclusion that that you see based on the ability of these factors to make communities safer. And so some other communities have less offensive, less discriminatory crime-free housing ordinances, and they of course would be less susceptible to legal challenges and maybe more susceptible to public pressure or legislative advocacy. But you are right to point out that what tool is available to you depends on the actual language of the crime-free housing ordinance and how it interacts with the broader community. I think Savannah, Georgia has a crime-free housing ordinance, and it's a majority Black community. And how you would analyze that ordinance under the Fair Housing Act would be very different than how you analyze the ordinance that's in existence in Faribault.
Thank you, Deborah. And I think one of the questions, I'm going to skip over a few questions here to get to one of the questions that I think relates to exactly what you just said. And we have Kat Fahey, and her question is, has legislative advocacy at the state level been effective, or are you optimistic that it could be effective for addressing this issue?
It would be so much easier if the advocacy happened at the state level. But unfortunately, these are local ordinances, and the advocacy has to happen city by city, town by town, with this city council and that town council, with this mayor, or with the police department that has adopted this program. So it is much more challenging to identify and engage in terms of a resource expenditure with crime-free housing ordinances because it's on the local level and cannot be state by state.
Thank you, Professor Archer. One of the other questions that I have is from Lisa Ann Landry. And the question is there a good source to see where these crime-free housing ordinances are in effect and how much they're used? And I think someone asked earlier about, whether they were in effect in Boston. I don't know if you're aware of any sort of source that might have a list of these cities and towns where the ordinances are in effect.
I am, and the name is not of the report is not coming up to me. It's in I have an article in the Michigan Law Review that chronicles and touches on some of these ordinances. And in one of the footnotes, I cite to the report where I mentioned in my talk that about 2,000 communities have crime-free housing ordinances, and that organization did that study and lists those communities in their report. And so if you can find my article in the Michigan Law Review, then you can find in one of those footnotes the organization. If I can find it before we're done here, I will also pull that up.
Thank you, Deborah. And so looking a little bit at sort of the research aspect of your paper and sort of, how you found all of the information that you were able to use. Daniel Tully wants to know, I'm curious about the research strategy that you employed to uncover police-based housing policy and their effects. So what would you say are, especially for folks who are, maybe interested in this area of scholarship and are writing, what are some strategies that you might use to sort of delve a little bit deeper into these topics?
I really want to give a fancy answer to that question, but I'm going to give an honest answer that I learned of 2 or 3 of these housing ordinances through my own advocacy and our work in the clinic, working on segregation issues and having advocates come up and say, this is a problem in our community. Have you seen this before or seen this anywhere else? And then after learning about those handful of programs, the search for others was really challenging. So the first step was finding the International Crime-Free Housing Association. And that helped a little bit because on their website, they have information about communities that have adopted their programs and tout these communities as success stories. So I was able to find information there. After that, I did some news searches to find reports and conversations about the adoption of these ordinances and programs, or people pushing back against them, or horror stories, and was able to identify a few more that way. But after that, I found it really difficult because it's incredibly time consuming to go city by city. And so I called on my amazing library liaison here at NYU and asked her to help me, and focused in, I said, on communities that had experienced shifts in demographics after the 2010 census as a place to look first. And then we found this other study and were able to look at those communities. And so it was really painful and time consuming, but mostly done by someone else. I had this amazing library liaison who was able to, through her work, go community by community and found a whole host of crime-free housing ordinances and programs.
Thank you, Deborah. One of the topics that I'm seeing a couple people have questions about is sort of, has there been any challenge to the right of the police departments to disclose information about arrests, especially arrest of victimless crimes? And also there was a related question, which is,